Thank you very much for the opportunity. I'd also like to warmly welcome everyone present. The past two presentations talked about the past 10 years of the modern Hungarian Criminal Code. With my presentation, however, we are stepping into a chapter of today's conference that is specifically focused on a research program preceding this conference. In this research program, a number of universities participated. So I, on behalf of the Széchenyi University, I wish to thank the Mádl Institute and the Miskolc University for the opportunity to participate. And the purpose of this exercise was to look through the comparative law classes to evaluate the Central European system in terms of the criminal cases or types of criminal cases that are prevalent in the 21st century or most broadly researched. Our research that was completed together with my colleague Ferenc focused on international criminal law and types of crimes. So out of the transnational types of crime, we focused on international terrorism. Unfortunately, the associate professor couldn't attend today, so he asked me to introduce his part of the research in just a few words. So he was focused on classic international types of crime, where the basis of punishment is not internal right, local right, but international rights such as aggression, war crimes, crimes against humanity, etc., etc. And in the book to be published after the conference, you will see that the professor analyzed all of these types of crimes and introduced the matter through the practices of the International Criminal Court and how these criminal acts are reflected in the system. I was researching the area of terrorism myself, and this particular part of the research is focused on this. The target countries include Hungary, Slovakia, Czechia, Poland, Serbia, Croatia, and Slovenia. I would like to tell you in advance that the objective was not to analyze the Hungarian position or the Hungarian situation. The idea was to focus on the legislative expectations that come from the EU that were also touched upon by Mr. Somora in his presentation. So we wanted to look at how they are manifested in these countries, and we included Serbia among the target countries because although, of course, they are not necessarily relevant in terms of EU directives, we still wanted to see how a country outside the EU would adapt to these requirements. As for the structure of the research, obviously there was a historical introduction, and the historical background served the purpose of placing terrorism and the criminal action against terrorism into a historical context, including the Belgian Association Clause and the League of Nations period. So we went back to the roots of this topic, and we also overviewed the UN Convention system as part of this research. It's very important to see this picture about the terrorist attack on September the 11th, 2001, because it represented a sharp change in paradigm change and in substantive criminal law. Prior to this attack, basically international law focused on some specific manifestations of terrorism, for example, terrorism attacking air traffic or anything that actually came up in actual practice. So the need for a unified framework system was intensified after the terrorist attack on September 11, 2001. Among international criminal lawyers, there is a certain degree of dispute about whether international terrorism reached the kind of level that was reached, for example, by crimes against genocide or crimes against humanity, and the current position is that it's not a closed system, it can be expanded. However, today the ruling position is that the basis of the criminal responsibility of those who commit these crimes would be rooted in international law. So it's mainly local law that is applied. And therefore, we narrowed down the basis of the research to the European context. And that's because we have a legal source here, by that I mean the EU Directive of 2017, that sets out the minimum standards with which states must comply with in their action against terrorism. So it offers a guideline as to what kind of facts should be considered when acting against different types of terrorism. As for the paradigm change, it's not just that there was a need for unified regulation, even at EU level. And here again, I'd like to refer to the professor's presentation who spoke before me. There was a criminal policy coming to the forefront that was focused on placing the possibility of criminal responsibility in focus. So we shouldn't just be focusing on the crime itself or the criminal who committed the crime, but we should actually try and detect these crimes in society before the process that would trigger the actual terrorist attack would even start. So in this context, at international level and at EU level, we needed to show that there are significant differences between the two groups of cases, because in one case we are talking about a specific terrorist act and related behaviors, while in the other case we had to look at the punishability of certain forms of behavior before the actual crime was committed. So we had to focus on the regulation of the actual terrorist act and then also on the regulation of the so-called terrorist-type crimes. And then coming back to the international context, I must say that the position of international lawyers is actually unified in the sense that although the punishability of these criminals is not on a jus cogens basis, but there are certain obligations that all democratic states should pursue, meaning to do all measures conceivable to prevent such crimes, because terrorism poses a risk to the life and well-being of all citizens. So it's important to note that everything needs to be done, including administrative steps to manage terrorism. And when we talk about management, as much as possible, we must create punishability for terrorism and related crimes in local law, and there must be also ongoing cooperation between individual states to be able to take effective action. Switching to the requirements of the EU, well, first I want to talk about the actual terrorist acts, and I didn't want to go into a deep analysis of the different acts. We wanted to focus on the regulatory system of individual countries and compare them instead. We all know that a terrorist act is a complex act which has a means and a goal. So a terrorist is not killing people because they feel so, but they actually do it for some kind of purpose that they see legitimate. like causing terror, destabilization, etc., etc. Those are all valid targets. In all of the countries you looked at, this complex nature of the crime is reflected in the criminal law. So in all countries it does, but when it comes to the methodology of regulation, there are significant differences. The simplest pattern was seen in the Slovak, Czech, Croatian, Serbian and Slovenian criminal code, which reflects the EU legislation. So in addition to describing the types of crimes, they give a description, so they don't actually put a specific name on the crime, but they describe the means that could qualify as a type of crime. And this approach is rather difficult because these provisions are difficult to both modify and interpret. So in that sense, I believe the Hungarian and Polish solutions are more favorable. In the Hungarian solution, well, we don't describe the actual target acts and the means, but we actually say that, for example, homicide is committed for some sort of reason. So there is a taxative list in the criminal code which, when actually matched with a terroristic target, should be regarded as a terrorist act. It's an easy to follow and transparent regulation. They are easy to modify and flexible to manage. The Polish solution is even more flexible, and perhaps I would say that out of the three compared legal technical solutions, this is the strictest solution, because in the Polish criminal code, and I'm just saying it as a side comment, that when it comes to comparative legal research items and report items, maybe by the time we discuss something, it might not be effective anymore. So I like to make the point that when the research was made, we found that under the partial provisions, the Polish criminal code sets out the types of crimes. It's the same as the directive, so there is no difference. But it qualifies as terroristic act every act that is committed for terrorist purposes, and they actually match it with a custodial sentence of at least 5 years. So there's a specific link to sanctioning. So this is the most transparent and, in my view, also the strictest of the three systems. Beyond that, of course, all of the countries looked at, including, of course, Serbia as well, also look at each stage of the act, the preparation and the actual committing of the crime, which are both punishable. So in that sense, the regulation is rather unified. And as a standalone crime, threatening with a terrorist act also appears in each of the three tracks. And I already wrote down some concerns about this and the anomalies, and there is no time really to go much deeper into this. But if you just think of my birth town, Miskolc, then at the time when there were scandals about the foreign currency loans, there was a person who made an announcement on the internet saying that if the act on the liberation of the foreign exchange loan slaves will not be voted for by the National Assembly, then he, as a representative of the people's power, feels entitled to murder members of parliament. And because of this case in Miskolc, in the Miskolc Court of Appeal, actually a case started about the threatening with a terrorist act, and the Court of Appeal of Miskolc actually discharged this person without any criminal charges in the lack of a criminal act. It's interesting to note that the prosecutor of the case knew me because we had some joint cases, and the person knew full well that my primary area of research was terrorism, and we had a little chat without, of course, mentioning any specifics or names, and he sought my views as to how we could best approach this case. And I am not proud of the fact, as a defense lawyer, that I actually did explain my views to this person, because the Debrecen Court of Appeal actually imposed a sentence on this person, and then the court of third degree, the Curia, actually imposed a sentence on the criminal for preparing homicide. So you can see that there were three criminal qualifications for the same act in three different courts. So in addition to the actual crime, we also looked at types of crimes that are not the actual terrorist act, but surround such terrorist acts. And the guideline and the framework resolution that had come before also included details of such crimes, like the management and participation in a terrorist group, participating in the activities, public incitement to support terrorism, recruitment of terrorists, training or participation in the training of terrorists, and traveling for terrorist purposes. So the study will also have a summary schedule where we try to identify in the legal systems of individual countries as to how the criminal law responds to these challenges. And our core finding was that the biggest issue, and then once again, I am quoting the points of Professor Somora, indeed, the biggest problem is posed by the regulation of cases in individual states where the facts are difficult to express in specific terms, but we are under international pressure to reflect these crimes in local legislation. By that I mean, for example, traveling for terrorist purposes or participating in training for terrorist purposes, or when a would-be terrorist actually learns on the internet how to put a bomb together when they don't know yet why they are putting that bomb together or what they would do with it. They are just simply learning at that stage. So from the aspect of substantive law, it's very difficult to define these crimes, and it's a struggle for most states. And again, quoting Professor Somora, I would say that they try to focus on the preparation of such acts. So they are trying to grab these facts from the aspect of preparation. So in the Serbian and Croatian Criminal Code, if someone participates in training, then they are not punishable. So if they are participating in such training, but they are not preparing for a specific terrorist act, then under the Serbian, Croatian, and by the way, Hungarian legislation, they do not commit a crime. So their behavior can only be interpreted as being a partner to the person who is offering the terrorist training. So it's a very far removed criminal liability, which also poses some evidencing issues in this process. Well, the Serbian and Croatian Criminal Code also has a similar situation concerning traveling for terrorist purposes, where again they focus on the preparation of the crime. The Czech substantive law ensures the punishability of most of these acts, but only in the context of specific terrorist actions. So what we see is that internal local laws really struggle with situations that are not linked to specific criminal acts. So they try and link it to the preparation for such crimes, which is quite understandable. And similarly to the Serbian and Croatian criminal codes, the Polish code does not establish a standalone type of crime, only linked to preparation. And the Polish penal code interprets recruitment activity as essentially linked to a specific terrorist act, and thus considers it as being part of it. So it was clear from the introductory presentations that the enforcement of the so-called enemy concept poses serious challenges to internal lawmakers, local lawmakers, and we cannot always fully comply with such requirements. When it comes to Hungarian lawmakers, although slowly, but we do respond to criticism concerning the legal literature. We have been saying for a long time that organization and management is not the same, so the organization and management of a terrorist act are two different types of things, and now management was also added to the criminal code. So we should mind the gap, so to say, look for gaps and find the right methodology to be able to help the lawmaker in such activities. Thank you very much for your attention.